All right. So I think Judge Cousins, I see, and Hillary, I see. All right. So we're going to move on to our second panel, which is also about people who have served long prison sentences and how to evaluate their sentences at the back end, right? We are so used to sentencing being a front end determination, being when you're convicted and how long you should be punished, but how should we evaluate, or what are the opportunities to reevaluate people's sentences at the back end? Parole is obviously the big one, but another important and relatively new mechanism is under Penal Code 1170 D1, which is a form of what I'm calling administrative clemency that allows prosecutors, CDCR, BPH, and I think sheriffs all to nominate people for resentencing and to go back to court. I think basically for any reason, but the reasons that we're very interested in are, for somebody who's proven themselves to be rehabilitated and may not be able to get to the board for one reason or another. And I know that CDCR has engaged in that to some degree, but limited. Our two panelists are Hillary Blout, who's the executive director of For the People, and Judge Richard Cousins from Placer County. Thank you both for joining us. Sorry for the delay a bit. Again, as I admonished our other panelists, we really, and as you probably saw, the meat of our hearings are really the conversations between the members and the panelists. So if you would keep your opening comments to 5 minutes, and then we'll jump right into it. So with that, Ms. Blout, we'll begin with you.
Good afternoon, and thank you so much for inviting me to this discussion today. I'm obviously thrilled to be talking about 1170, but specifically DA-initiated sentence review and sentence review units. I know that we all know this, but I just have to level set and start by saying that what drives me in this work is that these projections that we keep seeing, that we will not be able to see significant changes to our carceral footprint in our lifetime is terrifying. We know that means that we need better back-end reforms. And although we've been doing tremendous work on the front end, trying to limit the amount of people that are going in, we need better strategies and ways to get people out. And when we do have strategies to get people out, we can't have strategies that carve out people because they are classified as a serious and violent offender, because as we all know, the majority of people in our prison are labeled with this serious and violent offender and put into these categories. And we know that there's so many people within those categories that have been redeemed and no longer need to be there. So I'm hopeful because in California, I really do see that California has all the mechanics in place to be able to do this work and do it at scale. We are poised to be able to shift what we've been doing, what we did in the 80s, 90s, and the early 2000s. But what that really means is that we have to have a double-digit decarceration strategy to match the double-digit incarceration strategy that we saw for so many years. And I'm just very hopeful because I know that we have the mechanics in place to be able to do that here. So as a former prosecutor, before bringing the Assembly Bill 2942, the concept to Assemblymember Ting, I hoped and I knew and I believed that prosecutors could be involved in this fight to end mass incarceration. I know that a lot of people didn't believe that at first, that they would be willing to roll their sleeves up and get involved, and it would be this select few of, quote, progressive prosecutors. But I'm here to report, and we'll get into this in the conversation, that the issues inherent in moving this work forward is really about a coordinated strategy and about resources. Sentence review, and I say this often, is one of the most direct ways that we can address the racial disparities in our justice system. It's one of the most direct ways that we can attack what was done during our double-digit incarceration rates, right? So we talk a lot about all of the people that were ensnared because of the system and what we did to people back in the 90s and early 2000s and the 80s, but my mission is to go back and find those people and bring them home. Because while we're doing the front end work, there are thousands of people that are sitting in our prisons as a result of our bad, failed policies and things that we all collectively look back and say, oh, that was a mistake. So I am thrilled to be having this conversation. We started our work in Santa Clara County in the very beginning, just a small pilot, very little resources. My organization, Silicon Valley Debug, the DA's office in Santa Clara County, and the prison. And I'm pleased to say that we were able to, without any funding, actually with any of these other organizations, we were able to bring 8 people through this process. And we really took our time to understand all of the pain points in the system from start to finish, all the way from identifying people in prison to bringing them home and making sure that they had housing. So we're now poised to be able to expand this work and do this statewide. There are community-based organizations that are activated and ready to go. There are several DA offices that are activated and ready to go. Public defenders are activated, ready to go. And I believe that the prison as well will be a good partner in this. There's 2 distinct, I think about this as 2 distinct precedents that we have in California that might be able to be the funding stream that we need. What's that?
Keep going. Just giving you 1 minute warnings.
Sure. I can say it in 1 minute. But I'm hopeful that there are 2 distinct legal vehicles that we have that are precedent in this country that could hopefully be a bit of a hybrid to be able to create the funding stream that's needed to support this work throughout the state. So if we think about what we did with Prop 47, right, capturing the savings of people that were getting released and putting that money into a fund for prevention and treatment and also childhood education. And then if we also think about Senate Bill 678 and the incentive that was created to keep people out of prison, and when people were kept out of prison, those dollars went back to the county to support better services. So those are when I think about the things that we've done and the precedent that's here in California, I see, call me idealistic, but I see a lot of opportunity. And the only thing I see standing in the way is a coordinated strategy and a good stream of resources.
Thank you. That was bang on time. Good job. Judge Cousins, good to see you again. You're muted.
There you go. Does that do it? Okay. Thank you very much for the opportunity to speak to you. I have to look at this from when I started this business back when dirt was warm. The 1170D was just almost never used. I did it a couple of times in my career. It almost never came from the Department of Corrections except to correct a sentencing error. It was almost never used. And then in the last 3 years, 5 years, so much has changed to the positive. I do hope that when I impose a sentence, it's one of the things is to accomplish change. And it's great to have an opportunity to reward change when it happens. And so I'm very much in favor of the second look under appropriate circumstances and with a proper procedure with an eye to representing everybody's interests, but making informed decisions with new facts as people evolve. And so I'm delighted to be involved in hopefully improving the process. So I'm happy to answer questions and respond to comments.
Wow, that was quick.
I sense the mood of the group.
No, I appreciate it. And listen, I have to because you didn't use your time, I'm going to use just 20 seconds of the time to say that your memos on all of these reforms and that you've really educated the whole state in so many different ways. We don't always see eye to eye, but has really been extraordinary work, and I think a great service to everybody, because some of these things come very fast at us, and you seem to be like right on the ball, and I think doing a great service. So I just wanted to say thanks.
Well, thank you very much. It's an obsession. I'm in a treatment for it, but hopefully it'll all come out.
All right. So my first question that I want to open up to the group is to Ms. Blout. Okay, I'm with you. I agree that law enforcement should be part of this, but how many DAs have actually recommended recalls to the courts, and how many of those have been granted statewide?
I don't know the answer to that. I'm sure that you probably have that information, but I don't.
Is it 10? Is it 20? Is it 4? Is it 100?
I don't have a statewide number. I only know that I work with now 12 offices, and I've got over 200 cases under review.
That's not what I'm asking.
Right.
okay, of those 12 offices, how many have made actual referrals to the court, and how many of those referrals have been granted?
So in the offices that I've worked in, we made 8 referrals, and those people have all been resentenced. But again, it's not a lack of interest or will. It's 8,000 pages of a central file that I and my team go through, and trying to coordinate with public defenders that also don't have the resources to just add this whole bulk of work to their caseload. So, and to be frank, what we've done to kind of fill those gaps is we've been working with community-based organizations that also are not paid, that have been holding community meetings, to bring families together and parents together to help them to sort of backfill the questions that we know that the court is going to have.
Okay, so I totally appreciate that, and I see, and your work is, you've been a leader on this, but 8 cases, and it's not much more than that, I'll tell you, statewide, out of all the DAs and all the tens of thousands of cases and all the sheriffs is pretty scant. And one of the things that I think that we all, including Judge Cousins, want to try to find a way to make this a better avenue for a second look. I will tell you that the CDC, Jerry Brown was the person who dusted off 1170D at the end of his term and funded a couple of positions at CDCR to go look at these sentences. He was surprised recently that CDCR has made 150. He thought that that was very low number of recommendations to the court for resentencing based on good conduct. I'm not talking about the sentence correction. I will also say that of those 150 cases sent back by CDCR, which goes through incredible thorough review, the whole C file, ultimately with a recommendation from the secretary, 55 of those cases have been granted, only 55 out of the 150. I'm very proud to say that our office has represented 45 of those people. So something is going wrong that we have to be doing, or in my office being at this, my other job at Stanford. So I guess to you, Judge Cousins, if you agree, and it seemed like you do, that a second look sentencing beyond the parole board, that's parole. Okay, we talked about that for the last hour, but some way for prosecutors and the Department of Corrections to get involved here by recommending, how might we encourage more of these cases? Because even 150 and then 8 is not even a drop in the bucket.
I don't know how you increase it other than to stress from the judicial standpoint. I can only really speak from the judicial standpoint. Judges by nature are very conservative, I think, by and large, and get very concerned about people that they have sentenced. And I think we need to have a more education and encouragement to accept the evidence-based sentencing principles that we deal with now more frequently than we have in the past, and that has to translate into the post-sentencing context. I saw some of the literature that I think Tom sent out, and I was really disappointed at the level of judicial response. There shouldn't be that low level of response, particularly with sentencing error, but even with the more equitable considerations, judges have to respond. This is a part of their job, and we need to encourage them to be more responsive to it and to seriously consider it, and that it's okay to change a sentence. That has not been a part of our culture until more recently, and we need to encourage that. And I hope that the response is pushing educational response and not taking discretion away. I think that'll create its own problems. But I do favor encouraging judges to be more forward-thinking and to accept that people change, and that should be reflected in rewards of earlier release.
So as well, you well know, I'll get to you in a second, Justice Moreno. The courts have recently interpreted, and some of the first cases that have come up have said that courts have to review the evidence, but they don't have to hold a hearing. interpreting 1170D. Might that be a way to get judges' attention, that they would be required to hold a hearing when recommended by law enforcement?
That is certainly a way, but you're going to, I think, potentially, if you're going to increase the pool of people being considered for this, there's going to be a huge effect on judicial resources. And I don't know that everything requires a hearing. I do agree with the decision. We're talking about the McCollum decision, particularly most recently, which said you got to give them a chance. You got to give them an opportunity to explain themselves. I think that forces, at least to some degree, a second look without the expense, the delay of having a hearing. And I certainly favor that. It's just fundamental due process as far as I'm concerned. But to actually hold a hearing. Pardon?
McCallum was a case that we litigated, and they said it wasn't due process actually, but
I think it's due process.
I agree with you. Of course, the court followed up right afterwards and says you don't have a right to an attorney, and if you don't make your request to present evidence in a timely manner, then a court can deny it without hearing any additional evidence. So that's why the hearing idea is something. I hear what you're saying, that if we open the valve even more, but right now the valve is open so small, and even those cases aren't being heard. Maybe it's a matter of priorities. Maybe we should make sure those cases get adjudicated before we start opening the valve. I don't know. I should think that's an interesting way of thinking about it. Justice Moreno, I think you had a question.
Your microphone's off.
You're on mute.
There we go. It's been a long time since I was on the Superior Court, but I took over a department that had a huge backlog of these resentencing errors, mistakes, basically. So I understand that aspect of it. But I wonder, Richard, if you could just go over the process. And I agree that the judges by nature are very conservative, particularly if they're reviewing their own sentence. And you try to recollect why it is you impose a certain sentence, and you have to take into account a number of factors, I would think. So it's something that I've never done, but I would appreciate if you could just go over the process and then how we could educate judges that they have this newfound power to impose a resentence. And I imagine this would be months or even years after the sentence had been imposed.
Yes, it certainly can
Decades
occur
sometimes.
at any point. Once you get past 120 days, the court loses jurisdiction on its own to do something, and then depends on either the Department of Corrections or the sheriff or local commitments to bring the matter to the court. And now the DA's office can bring matters to the court. The process is amazingly sparse in terms of the statute, Justice Moreno. It provides for essentially no right of the convicted person to request this relief. It has to come from one of these third parties. It's done with a simple petition that's filed, and then the court reviews it. There's no requirement, as it has been pointed out, there's no requirement of a hearing. It can be summarily denied. It could be, on the other hand, it could be granted. There's always two stages to the process if it goes through completely. The first stage is whether to recall the sentence. That fact alone, irrespective of the merits. And the second question is, if you do say yes, then you have a hearing and you decide whether you were going to change the sentence. So it's kind of a two-stage process. And there are no rules of court. There are no standards in the statute for, other than more recently, the statute now provides for things that the court can consider. For example, post-conviction behavior, we now can consider that. That's affirmatively in the statute. We can consider resentencing, even though there was a plea bargain. That's now in the statute. So we have little bits and pieces that have been put in the statute, but it's still largely a creature of just kind of habit in the way the courts have handled these things, and different courts have different processes for doing it. It's not well structured, and I think that's part of the problem. It's not. I think it calls for uniformity, either through a rule of court that would facilitate the hearing of these matters, or by statute that would outline the factors to consider in the circumstances. But it's largely unstructured work of the court.
How might you structure it?
I just had one more question for Hillary. in terms of getting district attorney's offices up to speed on this and to be more open to the resentencing idea, what can be done? I know that tomorrow we're hearing from District Attorney-elect Gascon, who I would think has, I think he might have mentioned this kind of remedy in terms of his campaign, but I think it would be enlightening to see if he plans to strengthen or upgrade the DA's office, at least in Los Angeles County, in terms of taking a look at these resentencing options. So what can we do to make the DAs more receptive, more enlightened, as opposed to just, staying firm that person was sentenced, they're going to do their time. Why should we revisit this particular sentence? Unless there's a habeas issue or something like that.
Right, right. Thank you for that question. Yeah, I mean, I think that was a little bit of what I was alluding to at the outset with the 8 cases that we've worked on. Now, while the number might feel small, the work is not. It's not just about representing an individual person, since we don't even actually serve in that capacity, but it is, as you mentioned, Your Honor, it's also about engaging and re-educating DAs. So our work is very much rooted in approaching DAs, and not just progressive DAs in the state of California. It's about going and making this something that is bipartisan, because it cuts across all lines. We don't have time for partisan politics on this. Every single DA in the state needs to be involved. And so for many of them, they have never looked at a case in the way that we are asking them to evaluate this case. In court, as prosecutors, and I can say this from my own experience, and I think any prosecutor tuning in and watching this agrees, that there's a way in which we kind of shut ourselves off when we start to hear about childhood adverse experiences or all of the things that the defense attorney is bringing to the court. Right. We sort of see ourselves in these silos, and my job is to represent the victim and prove the case, and their job is to talk about the defendant and all of their experiences. And so this is a reimagining and sort of flipping it all on its head to go to DAs and say, here's the whole story, here's the whole person, and here's a lot you probably didn't hear at the beginning. And so it is a bit of a re-education. And I think that when DAs, and so I this summer went through the process of participating in a parole hearing case, because I really wanted to understand how that procedure takes place. And if the DA's experience is just showing up in a parole hearing and then thinking about their role in court, this is very different. Additionally, we're not identifying and moving cases involving the non-serious, non-violent, only those kinds of cases. We're wanting the DAs to look at residential burglaries and robbery cases involving guns, cases involving gangs, cases involving violence. And so you can imagine how that could feel when they're thinking about those kinds of cases in a particular way. And we're now coming and saying, we want to invite you to be thinking about these things differently. We want to educate them on what happens in the prison. If somebody is a quote gang member, but there's all of these other politics in prison that DAs, if you haven't gone into prison and walked around in the prison or talked to somebody that spent a lot of time in prison, you don't really have context for the politics that goes on. And so the way that a DA might orient themselves in reviewing a case is very different than what we do and what we try to impart in their review process. The other thing that I would mention is that the cases that we've worked on, part of our model, which is unique, and frankly, I'm the only one in the state that's doing this work in this way, is that we do this work in partnership with community-based organizations. Because the model of this is that there is a way that I can put myself out of work, and that the DAs and the community-based organizations and the public defenders can be working together, that we can start to build back some of these bridges and build back some of this trust. The other thing that I would say is that a lot of times when DAs are faced with this decision, and maybe there are things in the file or in the past that makes the DA hesitant because it's a violence case, for instance, you know, DAs they're elected to serve the people. And so we're really trying to have the people, the community-based organizations be part of these conversations also, so that DAs can feel like there's some skin in the game by community members. And I saw it happen in real time right in front of my eyes, where a group of community members all talked about the high school that they went to, the town, the part of the town they grew up in, and that they said, look, we know that this is a hard decision for you to make. And you said you didn't want to do cases involving guns and cases involving robberies, but we're here to tell you that we're going to be the ones that are going to be this person's neighbor, and we welcome him to be part of our community. So this model is a little bit different, but I feel like it's critical for DAs to orient themselves differently, because if they do, we can get some of that different orientation on the front end as well. And I also wanted to just add that in the beginning, when we started, and this is really, I just started in August of last year, we spent an entire year, and this is me and 2 people in the prison at CDCR trying to streamline a process. And it took us over a year to be able to get a process where the requests that we're making for cases is now centralized, right? So it has also been a very steep learning curve to understand all of the barriers, or all of the ways in which these state actors aren't actually coordinating. I was surprised. I didn't know that the public defender, the DA, the prison, probation, parole, reentry groups, community groups, like there is just a lack of communication and coordination. And so going through this process, we have been able to see all of these pain points. And this is what I was saying earlier about, now that we're working in partnership with 11 offices with over 200 cases that we're trying to get through, the delay between more offices and more counties is really just more of a coordinated effort and more resources to be able to look at more cases.
Dean Richardson, did you have a question? I have plenty. Does anybody else have a question before I jump in? Yeah, Assemblymember Kamlager-Dive.
I guess I'm just kind of curious about, this has made me think about one of the prior committee hearings we had around restorative justice. And I'm wondering, who else do you think should be involved in this? Because right now it's really sort of, very rarely is it the defendant, it's mostly DAs and judges, but if you don't sort of change the players, then you're not really going to change the game. So if you could sort of reimagine who else could be in this space helping to, jumpstart more successful 1170D motions, I would be curious.
That was on my talking point to mention that. So thank you for that question. You hit it on the head. One of the, again, thinking about the pain points or some of the barriers that have come up through this work, prosecutors aren't going to say no just because the victim says no, but the victim's perspective on the release weighs heavily on their decision making. And so, as many of you know, and I think you'll be hearing from my good friend Jay Jordan, I think tomorrow, to talk about crime survivors, many of them have not felt that the way that they were treated or the way that the case resolved really helped them to feel whole and feel healed. And so we have been really, really focused on trying to see if there's an opportunity, like when we're doing a look back, right? We're looking back at the whole thing. How do the victims feel about this? Are there opportunities for more restorative justice or some restorative justice in this process as well? So that's very much, I think, something in that realm that is elevated could be really, really help to accelerate this process.
My sort of second question, and then I will not have any more, is that I don't think, no commitments to that. But oftentimes you will hear prosecutors say, a deal's a deal, right? If you've, agreed to something. And so don't come at me because now you have buyer's remorse about something, right? And so this might be sort of a question around sort of culture change. But the other part is, you know, I mean, prosecutors aren't public defenders, they're prosecutors, and that's their job. And so is there a way to sort of reconceive what a win would look like or could look like for these offices in a way that still, you know, administers justice in a way that is right also for the defendant, right?
Let me respond to that. In my view, a prosecutor does not represent the victim. The prosecutor represents the people of the state of California and what is in the best interest of the people of the state of California. And sometimes that role involves interests that don't necessarily converge with the victim. And there's an independent responsibility to administer the awesome power of the prosecution in a measured way. And this is particularly true, I think, in these post-sentencing second look cases where it's in the interest of the people of the state of California that if a person has in fact changed their lifestyle and have benefited from what we supposedly send to prison for, that there should be a concomitant reward for that and a benefit to them that they can strive for and earn. And that is in the interest of the people of the state of California as well. And it cannot be confined, in my view, to looking at the victims only. Certainly it's a part of it, but that's only a factor to consider.
And if I
I
can,
appreciate that, because oftentimes, you know, prosecutors do invoke the victim quite regularly and forcefully in, you know, their narrative. So I do appreciate you saying that.
and if I can just sort of dovetail on what was said, the idea that this process is really about a reckoning that prosecutors need to have with the way that the profession has been designed and has been built and the way that we've been carrying it out. So we have to be honest and say, we are not experts in figuring out if this person is, we don't have a crystal ball, right? And we make these guesstimations about what public safety needs, and we look at the rap sheet and we do the best job we can with thousands and thousands of cases, you know, kind of waiting for us in the wing. But we have to be honest about the fact that we're making these guesses and we have no idea how quickly a person's going to change their life around. We just sort of have those notions in our mind. And so I think that there is an openness to look back and not just like a deal's a deal, and so why are you coming back to me? But instead that, one, people change, we know that. Two, it's not fair if people are serving a sentence today that nobody's getting anymore. That just doesn't seem fair at all. And I think it was mentioned earlier that if we want people to rehabilitate, give folks a reason to do that. If they're staring down the barrel at a life sentence, what's the incentive for them to do anything differently? Although we've seen a lot of people that have taken strides regardless. But I do think that I have not personally heard a deal's a deal. Why are they coming back now? Instead, it's been, well, tell me more about what you've learned or how this person has in fact changed.
Senator Skinner?
Thanks. I want to go back to the reference to the 1170Ds. And we heard in our previous discussion, there was expression that the governor's review of even the parole decisions, governor gets to review, and that politicizing of that review has affected, you know, overturned a number of parole cases, right? So there's been sort of a theme about how the politicization of various of these processes may affect it. So what I guess I'm asking Judge Cousins, but our other former judges on our commission, or even Hillary, you can opine on this, but you know, I wonder if you feel like in the 1170D, should it go back to judges, or should it have just be designed where CDCR does that assessment? And I raise this partly because while all judges aren't elected, many are, just like DAs are elected, and whether this notion of, you know, that you would be that it might come a factor in the election that you agreed to release a person or something. So I wonder your opinion about whether we should retain that process within the 1170D statute.
I feel it's important that the judicial component remain. We're in the business of resolving competing interests, and that's what this is all about, resolving competing interests and establishing a direction. And I would hate to have that relegated to a strictly administrative decision when there is no real check on that decision. I think it's healthy that judges are elected. I think it's healthy for the judiciary as long as that's kept in balance. I think it's healthy that people who are in touch with what's going on in their community have a role and a say in what's happening. This is not to say that it's a human system. Absolutely it is. So it's going to reflect the strengths of humans as well as their weaknesses. And hopefully there can be enough procedural protections and requirements built into the process that we can account for as much of that as possible. But I don't think the answer would be to take it away from the judges and leave it administratively.
Would it be wiser to put it before judges who are other than the judge who sentenced?
That certainly provides a more independent second look, or the potential of it. And in some cases, I think that would be perhaps valuable in a very high profile case. But I will tell you this, that I've been on the bench now for about 44 years. I remember maybe a handful of the sentencings I've done in particular cases. You deal with so many hundreds of people, and after a time, while you focus completely on the case that's in front of you and you make an informed decision, my tendency is to, okay, dump that bucket, pick up the next one, and move on down the line. And so that's why another judge looking at my sentence doesn't bother me so much, because chances are I wouldn't remember the case anyway. Fine, if that's a better way of doing it. The handful of cases that you really do remember, I sort of think that for those cases, it is kind of valuable at times to have a person who's experienced in the facts, who saw the trial, saw the witnesses, or heard the victim's statements and it resonated with them. That's valuable information. Now, if that discretion is abused, I mean, there can be ways of dealing with that, of course. But I think to preempt that would be a mistake. And I think it would make it a more mechanical process than a human process. And I think at this point, it calls out for being a human process.
This is Judge Espinosa. If I could just add on to that, and I would say that if you use Los Angeles County as an example of how larger counties handle these types of issues, resentencing issues, Prop 36 resentencing, habeas petitions, they're centralized in one court. And the advantage to that is that it promotes sort of consistency and fairness along the spectrum of resentencing in those types of decisions. And it's another way to get fresh eyes on a case, to take a look at it, where the judge who's making the new decision on the petition for resentencing might not be influenced. I mean, I agree with Judge Cousins that to have an intimate knowledge of the case and how the trial went down, if it was a trial, would be important. But there's also some benefits to having fresh eyes on a consideration for resentencing.
That's a hill I would not die on. I mean, as long as a judge is making the call, I think that's the most important thing. And in the vast majority of cases, it won't material. I think it'll be fine. But I would feel that's a reasonable suggestion.
I'm going to add a couple of cents here. First of all, I should say that I originally met Judge Espinosa when there were a number of cases in Los Angeles where the district attorney felt like they should be revisited. And before this legal mechanism existed, and we were sort of came together to develop a habeas claim that went before Judge Espinosa. So he and I go way back on this process. And I do think, again, this is anecdotal, but I'd be curious to see the data. That's like kind of my recurring theme. I'm not so certain that going back to the original judge is as there's intuitive negative outcomes there. But I have been before a number of judges who really appreciate and be like, wow, I remember you, or I am so honored or proud or whatever it happens to be to get a chance to correct the sentence. So I've seen a lot of positive outcomes that way. On the other hand, the centralized system in Los Angeles, it not only gives consistency, but there's a lot of things that people accomplish in prison and the rules in prison, what's an RVR and what's a classification score, and a lot of the inside prison baseball that typical Superior Court judges are not familiar with. So I think that's difficult. I'm on two minds of that, but I do have a couple of questions. All right. So to both of you, but let's start with Judge Cousins. So we've talked about two different kind of problems. Do we expand the pie of people coming back for second look sentences? Because I think that we can all agree that the combined universe of less than 200 cases over 3 years is not making a real difference. And I will point to two federal examples that I think are kind of interesting and way on the other end of the spectrum. The first is, it was a bill, so it hasn't passed, but Cory Booker proposed that anybody who served in federal prison 15 years, they get to petition themselves to come back, right? That would obviously really open up floodgates. And even actually the First Step Act that was passed under President Trump, that also provides a mechanism for prisoners to petition directly to courts in what they call exceptional circumstances. So, and then the other side of the question is, how do we improve the process so that those cases that do come through, as you were saying, Judge Cousins, have some more structure, whether it's a hearing or whether it's specific standards. I guess the hearing part, you think, appointment of counsel. So I guess if you could address those two different things, how might we reasonably expand the pie? And once the case has been nominated for resentencing, what's the best way for the court to review it?
It's so hard to set limits. It just seems like you crack the door a little bit and it's really going to open things up. But it seems to me fundamentally fair that if a person has been in custody for 15 years, that it's not unreasonable to say, hey, has this person changed? That's just not unreasonable. And while there may be a big push initially, then I'm not so sure that that's not unfair, particularly if we can create a process which does not automatically require a full-blown hearing in every single case. I mean, if we can fashion a system that is fair, gives both sides an opportunity to present their views, but does not automatically take up several days of court time when you hear witnesses on things, then that may be a reasonable approach. Simply saying arbitrarily after a certain period of time, and a generous period of time at that, that there's an automatic right to, or an open right to request. And then then the burden would be on the petitioner to establish the good basis for doing that. I don't have any other specific, the only other way you can increase the pie, I suppose, is to individualize it by a certain class of crimes, property crimes, drug crimes, personal crimes against the person. You can treat those differently. You can establish rules for that. That's another approach rather than simply saying a number of years. You could have different levels of intervention based on the type of crime. I don't have any real suggestion beyond that. In terms of the court process, I think it's important to establish incentives. Judges, like everybody else, I think work best against deadlines. I think there is a need for having some limits put on a decision made on these applications. And I think they do require affirmative responses, if only by writing. There is an obligation to respond and explain the decision. I think that will help the process. I think an informed counsel process would be appropriate. I've been told that most likely you have read the memo that I prepared in response to the request by CDCR to do some resentencing to correct a variety of things. And in that, I put my own procedure. I came up with that on my own, and it's thinking well, that sort of works. And ultimately, the Judicial Council suggested, our working committee and the Criminal Law Advisory Committee came up with a proposed rule of court that basically followed that outline. We can talk about that later if you like, but I think that kind of process doesn't automatically trigger hearings. It does give an adequate opportunity for input. It allows courts to give tentative decisions and then attorneys to respond to that. So if everybody agrees, it would you can move ahead. I think it's important to change the sentencing law a little bit to make sure that if there is a resentencing and if the defendant has not requested the opportunity to be there, that sentencing can occur right then without the appearance of the defendant. So you don't have to haul people back from CDCR, which is a big pain. So I think those kinds of things to tweak the system a little bit. But basically, I to tighten it up, to give some structure to it, and maybe another thing that can be considered in the rule of court, it would be maybe expanding the list of things that courts can consider in making these decisions. We have a partial list in the statute now, but it's very limited. There can be other things. Participation in rehab programs, specifically that, psychological evaluations, other kinds of things that I think are important in understanding an individual and where they are. Courts ought to have access and to consider those things. So that can perhaps be fleshed out a little bit more as well to help facilitate it.
Thank you. Ms. Blount, do you have a reaction to that? I also wanted to say that I have also been surprised by the lack of coordination and cooperation between state agencies like CDCR and DA offices on just getting basic information, data, and central files. I think that seems to be, that's what you were alluding to in terms of being able to make this process be a little bit better expedited, at least from the district attorney's office. Is that right?
Right. I mean, I think, not to just keep going back to this, but I mean, the delay, the way you get the pie bigger is funding. It's not coming from courts that are, and I've had similar experience. Every single case that's gone to the courts, and granted it's been small, but it's been, impactful. Every judge is enthusiastic about seeing this person and thinking, wow, I get to be part of this person coming home. They did all of this work. This is incredible. Wow, what an opportunity to do justice today in this way. And so, the delay or the way that we get this bigger is for there to be more funding, because the bottleneck now is about getting these cases reviewed and getting them ready for court. That is what
funding to the DA's offices, funding to CDCR.
I think it's funding to everybody. I mean, like I said, there has been not a single dollar that has been identified for, at least for DA resentencing. I'm not an expert on the 1170 CDCR initiated, but I know that for us, when we got our work started, we basically were like the stepchild in the 1170 unit at CDCR saying, can you break us off some too? And we want to, we're not exactly the same and we're not totally funded under the work that you're doing, but we're also trying to identify people and get folks home. And so, without funding, they were able to give us a little bit of, not charge us to get cases. And like I mentioned, a year after, now there's actually a unit that's giving us files and expediting the processing of that, which sometimes in the beginning, that was taking 6 months to go from a DA wants to look at this case, can look at the stats and can see based on the classification score or the charge or the time served, okay, this seems like a viable case. Okay, I'll be back to you. Give me 6 months. Like, that's unacceptable. So we were able to push that through and get this unit set up in CDCR, which I don't even think is funded to exist. And I just had a conversation last week with the public defender's office, who of course wants to be able to do this work. We've got 45 cases in San Diego that we're trying to connect with and get reentry plans plans and they don't have the funding, and they're going to try because everyone's going to roll their sleeves up and just sort of like find a way to make it work. But that really is the delay. And I'll give you one other, example. Last Thursday, I was on the phone calling family members to get a better sense of what the reentry plan was going to look like, because the DA that's considering the case had some questions that we just didn't get answered from the letters that were coming from the incarcerated person. So I'm on the phone with the wife. What does your house look like? Who lives there? What's it going to be like? And like that conversation opened up so much to help me to go back to the DA and say, this is one of the tightest reentry plans that's out there, because it's a wife and her parents, and it's going to be a good place for this person to land. But I'm one person, making these phone calls. And so, as I said in the beginning, this is not a lack of will. I don't think that judges are not there. I think they're enthusiastic about looking back at these cases and seeing how people have changed, or being able to use their discretion that they didn't have before when they weren't able to strike gang enhancements and other types of enhancements. So again, that is where the bottleneck is. That's where the bottleneck is.
We only have a couple more minutes. I agree. I think there was funding, and then the Mike Masters and his team there was with the budget crunch, and hopefully they're back at CDCR. Obviously the DAs have funding issues with their boards of supervisors. But anyway, we only have a couple more minutes left for this panel. Are there any other questions from the members?
This is Espinosa. I just wonder if there's some way to incentivize local DA's offices to create units to respond to these cases and review the cases in a timely fashion using state funds. But just a thought.
Absolutely. And I think that's exactly what is something that could unlock a lot of these bottlenecks. And it's the public defenders are asking for funding so that they can appear to do the representation and reentry planning that's necessary. DAs are needing funding so that they can set up units. And I think that right now, post, in this COVID era, we have seen some DA offices that have been able to sort of reallocate resources internally. And that's been kind of our push during this time, since courts have been largely closed and the trial cases have slowed down. But some of those have also accelerated other needs in both DA and public defender offices. And so, Judge, that's exactly right. That's what we've seen and what we've heard, is that DA offices hoping to get funding so they can have a team of people to be able to evaluate these cases, so that it's not just on one person in the office, or myself and my team and our limited resources.
Any other questions? All right. First of all, just a couple things. I think this idea of a second look is extraordinarily interesting and important beyond just parole. Obviously, we spend a ton of parole. There's a great deal of public interest in this. Just for what it's worth, we have almost 200 people observing today's hearing, which is our biggest. So I think there's a great deal of interest, and we're just at the beginning of thinking about this. I think it's very interesting to hear from both of the judges, and from folks in court. The way that I thought about, courts and judges is it's this, fire hose of people, going in one direction, and then the laws that are now trying to send people back, like Ms. Blau has said, and with Judge Espinosa and Judge Cousins. Judges, in many cases, love to be part of this process and recognizing people's rehabilitation and awarding freedom. I imagine being a judge sentencing somebody to prison is a very hard thing, even if they've done a bad thing, and to be able to reward somebody for earning their way out is probably really an extraordinary circumstance. How we get the courts to do it in a way that makes sense, I think is a big challenge. As I like to say, no good deed goes unpunished. This is the beginning of the conversation. So, I suspect we'll be back. I know we'll be back in touch with you for, further advice. Thank you so much. Again, also, I already said, Judge Cousins, for your work outside of this, but Ms. Blount also for all of your work leading the charge for the DAs. I mean, you've really been the voice here. I know that DA Rosen, helped sponsor the bill, but, this wouldn't have happened without you. So Thank you. We're going to take a 5-minute break before our next panel. So let's all please reconvene at 3:40. And thank you all very much. I'll see you
Thank
soon.
you. Yeah, Pete, good to see you again.
Great to see you, Richard.
Take it easy.
All right.
All right, if everybody could come back to their chairs. We'll get started in a second. If the committee members could come back, it'd be great. All right, I think we're mostly back. Senator Skinner, of course, when you can join us, that would be terrific. Can everybody hear me? Yep, all right, great. All right, so we're moving on to our final panel of the day, where we'll be hearing directly from people who have served life sentences and obviously been released. As always, we deeply appreciate hearing directly from people who have been personally impacted by the laws that the committee is considering. Our panelists for this group are Sam Lewis, who is the Executive Director of the Anti-Recidivism Coalition, Adnan Khan, who's the Executive Director of Restore Justice, and Shanae Polk, who's the Director of Operations of Second Call. Mr. Lewis, we'll begin with you.
Thank you, Chair Romano. Thank you, everybody, for joining. Hello, greetings. So you touched on so much in the previous panels. Just a couple of things that I want to do. First, I spent 24 years inside the system and went to the board 9 times. Ultimately, I went to court. Judge Espinosa actually denied my writ, and it was overturned by the Court of Appeals, which sent me back to the board. And since then, I've been home for almost a decade, and I think most know the work that I've done. I'd like to talk in this panel the importance of rehabilitative programming in terms of life sentences within the California Department of Corrections, specifically those that are in maximum security prisons and outreach or farther away locations like Pelican Bay, Calipatria, Centinela, High Desert. But before I touch on those, I want to just kind of touch on something else that I think is important that we look at in a broader sense of both criminal justice reform in the state of California and nationally. We all know the United States incarcerates more than any other country in the entire world. One of the things that we really need to be aware of when we talk about biases, in the United States, African Americans, specifically African American men, are incarcerated more than any other demographic in this country. We're sentenced to life sentences more, we're sentenced to life without the possibility more, we're sentenced to death more. This is true both in the state of California and nationally. When we look at countries like Norway, which we visited, in Finland, as examples of possible solutions to our criminal justice system, we must also consider that these countries are homogeneous countries that have one race, basically. They never took a race of people, enslaved them, and made them less than a 3/5 human. When we look at extreme sentences, I believe we must also consider the systemic racism that's built into our system, both in California and nationally. So I think that should always be something that we consider. I'm sure with the expertise on this panel that I've seen that I was super amazed with and wanted to jump in so many times, that'll be considered. So in terms of rehabilitative programming, based on my experience being incarcerated and as a service provider, one of the things that I know is participating in rehabilitative programming, including therapy, self-help, and education make a huge difference. I'm participating in all those things. We provide services in those areas. And I believe because of both my experience and the success we have as an organization, it does make me, in fact, what I consider a subject matter expert. Rehabilitation starts, and this was something that was said earlier. If you had told me this 10 years ago, I would have started earlier. Absolutely. The day rehabilitation starts is the day that you're locked up. Or in this case, we'll look at the Department of Corrections. One of the things that happened 2 years ago is the Department of Corrections tried to begin to implement rehabilitative programs in reception centers. However, it was not as robust as it could be. One of the things that we learned immediately when providing programs in reception centers was people did not realize, even repeat people that came back repeatedly, 2, 3, 4 times, they didn't realize many of these programs existed. And so normally when a person goes into a reception center, they're there for about 90 days to be classified, doing nothing. The process that the CDCR uses to determine where a person will be housed. And during this time, you have very little contact with anybody other than staff members to determine what is your threat level, where you should go, et cetera, but you're not exposed to any type of hope, like people that have been incarcerated that tell you you can make it if you do X, Y, and Z, that tell you to begin to start addressing your issues immediately, and this is how you do it, that literally instruct you on your pathway to freedom, even if you have a 20-year sentence. Now, when we discuss rehabilitative programs, it's a different breakdown. Oftentimes we bulk them all into one big clump of programs. So rehabilitative programs include self-help, which is facilitated by people that are incarcerated. Wait a minute, where my notes go? Okay, my notes, I lost my notes. So I have to ad-lib this, literally my notes, but I sent them to Thomas. So they're grouped into 4 different pods. So you have 1, self-help groups that are facilitated and often created by people that are in custody. Long before the move towards rehabilitation in the Department of Corrections, I was inside, literally on a yard where we didn't even have Narcotics Anonymous or Alcoholics Anonymous. So we started creating our own programs. And this is what led us, many of us from Soledad Central, out of prison. Literally created our own programs. We had Keith Watley on, who was one of our participants. 1 minute left. Okay, this is not going to be very easy. So
we'll talk some more.
I have to go to a board meeting in 12 minutes. I'll schedule this for 3 o'clock. So literally you have therapeutic programs like dog programs. You also have therapy, which is done by licensed clinicians, which is necessary. And then you also have what you call college programs and educational programs and vocational programs. All of these are important for the individual to be prepared to be released. The last thing I'll say with such short time is this. When we look in terms of making this, or looking at this in terms of changing the penal code or a statutory code, which should be, in my opinion, put in, is this should be something that's mandatory for all people to have access to, not just places that are close to huge metropolitan areas like Marin County or San Diego, but places like High Desert where it takes 13 hours to drive from LA, or Pelican Bay where you have to fly in. These programs are vitally important. And I say that from the position, not just of a person who went through them and who has been hugely successful in the community. My staff, which is over 75 employees now, 70% of them are formerly incarcerated and are doing amazing things in the work. Our membership is over 1,600 people. When they come home and they have gone through these programs and we assist them with resources, they do amazing work. Firefighters, trade union jobs. I can go on and on and on. The bottom line is that we need to figure out a way to put more programs inside the Department of Corrections in all facilities. Last thing I'll say is this, I know where the money's at. Right now, Geo Group, which is a for-prison profit company, actually has a $50 million a year contract to provide cognitive behavioral therapy, which has been deemed to be a failure. And yet they're given $50 million a year. This should go to programs, community-based programs that have deemed that you can see are successful, that brings hope into the institutions and that leads people out, not just to freedom and redemption, but to creating a safer community across the state. Thank you.
I know that you have to go, Sam. So, but before we get to the others and before you leave us, I was just wondering if you could quickly answer one question.
Absolutely.
And you sort of skipped over it. And whenever you and I have talked about this, it's always, you went to board 9 times.
9 times.
So that means 8 times they say that you're not suitable for going home. Over what period of time was that between the 1st and the 9th? The
first time I went to the board was 1999. And then the last time I went was 2011.
And I know you as a pretty introspective honest person. Do you feel between the first time and the ninth time that you had changed as a person, or were you were they just reviewing the same case, the same person, or did you feel like you evolved a bit or changed or was more prepared to be released? Is that a fair way of asking the question?
I absolutely believe that I changed from the first time until I continue to prove even today. I continue to.
We all do. Yes.
I believe the last 3 hearings were totally unnecessary. Nothing changed except for time, more programs, but literally my thinking was I'm gonna come home and I'm gonna figure out how to make a difference. I don't know when, but I'm gonna just keep working on me until I get there.
Okay. Thank you very much. And when you do have to go, we appreciate your time. So
Thank you.
thanks. Mr. Khan?
Just what year was that? What year was the year that you felt that when you said X number of parole hearings were unnecessary?
So 2011, 2010, 2009.
Then you got out when?
I was denied 1 year each year after the first and second. And I came home January 12th, 2012.
And now you're the head of the Anti-Recidivism Coalition, which is, how big is the budget now, and 75 employees? And
the budget now is an $8 million a year budget, 75 employees, 70% formerly incarcerated, 1,600 members, 2 housing sites, one for juvenile people that have been convicted, one for long-termers who are coming home. We also help create the firefighters program. We have a building trades union pre-apprenticeship boot camp that has now placed over 200 people into union jobs. We've helped write, co-sponsor, and pass 26 pieces of legislation now, including my favorite this year, which was Senate Bill 203, because it stops juveniles from being interrogated and forced to admit things that they haven't done, in my opinion.
all right, thank you very much, Sam. Mr. Khan?
Yeah, thank you for having me, Mike, and thank you everyone for, I know it's been a long day for some, and for those that are still here, I really appreciate it. It's kind of indicative of a parole board hearing that's being done like the third person in the day. So I really, really appreciate everyone that's still here. So I've heard a lot about the term second look. We need to talk a lot about second look, and I do truly believe that that is a great idea. But right now, I'd just like to, just for a moment, erase that thought and rethink, for all of us to just rethink and reimagine justice and talk more about a first look and create structures for a first look, so that way we don't have to go back and try to put bandages on something that requires surgery. So today I'd like to center my talk around static incarceration. Yes, we've heard a lot about mass incarceration, but specifically I want to talk about static incarceration, which is how many people are incarcerated in prison that are just stuck there with either life sentences, life without parole sentences, and people even who have determinate sentences, but just have a fixed number that they just have to sit there in their cell, complete, or depends on what facility they're in. And so I want to highlight that. And as I do, I would love for everyone to really think about what first look structures in our justice system can look like. And there's 3 significant moments where I also want to bring in my personal examples of where risk assessments determine my quote unquote safety and how those risk assessments have consistently failed me. So first, I would like to quickly start off by how did I even end up in prison? I don't want to spend too much time on this. You can Google it. It's all over the internet, and I'm sure a lot of people won't have a hard time finding it. But I do want to say that by the time I was 17 years old, I was with layers and layers of trauma and abuse. I was a parentless, homeless, high school dropout. And under those conditions and under those emotions or unprocessed grief, what I agreed to was a snatch and grab of marijuana. The idea was no guns, knives, or weapons were to be used. Take $1,000 worth of marijuana in a fake drug deal. And once this gentleman, who was a young man, he was 19 years old, he hands it to me, that I would run away into a car and we would drive off. I didn't know this young man. The gentleman who set up this robbery did know him, and that's why they asked me to do it. And impulsively, I agreed. The person who was the getaway driver, I did not know him at the time. When the young man handed me the bags of marijuana, it appeared that the person who was a getaway driver pulled this young man out of the car, and it seemed to me that they were fighting in the middle of the road. I get out of the middle of the road, or I get out of the car, and I yell to him, "What are you doing? Get back in the car. What are you doing?" We flee the scene, and the next morning at 2 a.m. I was arrested. And this entire time while I was going through the forensic process, I was thinking like, am I going to, is this a robbery? Is this for possession of weed? When I finally went to interrogation room, I was told that I'm being charged with robbery and a murder. And as soon as I heard that, I remember just crying and breaking down hysterically. It did not make sense to me at all. And soon I learned about the felony murder rule that said that, well, what I learned was that young man had lost his life. And later I found out that the person who was the getaway driver was bipolar schizophrenic. He was 21 years old. He wasn't taking his medication, and apparently he had a concealed knife on him, and he took the life of the young man that night. So quickly I learned about the felony murder rule. The felony murder rule said that if I'm involved in a felony, and my case was a robbery, I'm equally guilty of the murder. And so when I went to my jury trial, the jury's job was only to find me guilty of an intent to commit a robbery, which I was guilty of. I admitted to that guilt, and which I am currently still guilty of. And once the jury found me guilty of that, the next phase was the judge's phase. But before the judge's phase of sentencing came up, this is where my first interaction of a risk assessment came up. So I had a probation report and a probation hearing. And in this hearing, this is after my guilty conviction, but prior to my sentencing. And in this probation report, after those findings, they said that had it not been for this mandatory 25 to life sentence, they would have granted me probation. They saw my remorse. They understood that I do not pose a risk to public safety. And even though I had just got found guilty of robbery murder under the felony murder rule, they suggested probation. However, they couldn't give it to me. So I went to the judge. The next phase was like I said, sentencing phase, and I was sentenced to 25 years to life. Immediately when I was sent to when I was sent to state facility, and I'm being very conscious of time, I'm going to try to wrap up really quick. When I was sent to reception center, which was right before I was actually housed permanently into a maximum security prison, the risk assessment that sent me to maximum security prison was this. They said, since you have 25 to life, we're going to give you more points. And the higher the points, the likelihood of me being on higher level maximum security prison. And so because I had 25 to life, my points jumped up. Because I was 18 at the time of my crime, my points jumped up. Because I was not married, nor did I have children, my points jumped up. Because I did not have a high school diploma or a GED during the time of my crime, though I had it during the time of that interview, my points jumped up. And I had not been to the military, so my points jumped up. All those factors said that, you know what, I'm a threat to the population of prison. And therefore, as a young gentleman, I'm going to be sent to a maximum security prison. That's the second interaction of risk assessment that failed me. The third interaction of risk assessment that I had was a couple of years later in a maximum security prison. We're on a lockdown, and this lockdown is 24 hours a day, 7 days a week in your cell because a riot had erupted. And in that riot, a gentleman had lost his life. And I was escorted to what they call a documentation hearing. And the documentation hearing, they said, hey, so, you have about 22, 23 more years before you go to a parole board. And these are the steps that you need to take and classes that you need to take in order to be suitable, hopefully, eventually. And as a young gentleman in a maximum security yard without any rehabilitative programming, for you to tell me to take rehabilitative classes was so, just did not make sense to anyone, and particularly for me. So multiple times I did not have any relief to get out. The only relief came 16 years later. Thank you to Senator Nancy Skinner, Assembly Member Kumlager, who passed Senate Bill 1437, which amended the felony murder rule. And we talked earlier about judge's discretion, and I can go both ways on this, but I want to say the same judge that sentenced me to 25 to life, re-sentenced me to 3 years. I had already done 16 years, and she released me on that day. More importantly for me, and perhaps more for this conversation, I did not go to the parole board. Also, in addition to that, that same judge did not put me on parole or probation. She said that's excessive, that you do not, she perhaps looked at my file, did not believe that I needed to be on parole or probation. So I did not go to parole hearing or parole board, and I was not put on parole or probation. Our legal system had placed a permanence on my identity as a quote unquote dangerous 18-year-old until I eventually completed perhaps 25 years to make another assessment on my safety. That's a quarter century. And what a person did, I'm sorry to say, I cannot change. I cannot change what I did. I wish I could. I truly wish I could. But who a person is can absolutely change. And the latter is how the infrastructure of our justice system should be built upon. So one, my recommendation, I'm closing off with this, I promise, Mike. One, my recommendation is to significantly reduce or eliminate life and extreme sentences to at least allow people to appear before a parole board or an 1170D process heard earlier, or perhaps something completely different as a proper apolitical release review, and not let a number determine when they should appear in front of a parole board or an 1170D process or this new idea that I'm talking about. Two, and that's for people who are serving life sentences, like I said, life sentences, life without the possibility of parole sentences, anywhere in between that. Two, I highly, highly recommend to create a similar structure for people who are sentenced to determinate sentences. Those not sentenced to life, but sentenced to 5, 10, 20, 46 years, just like in the case of my friend who has been sentenced to 46 years, and a person can commit 25 years to life of murder right now and still go before the parole board, to the parole board before he can, just because he has determined a 46-year sentence. We need other vows to allow people to get out of prison and show that they are no longer a threat to public safety. I just want to say too, any life sentence is a death sentence. I was sentenced to 25 years to life, which means I was sentenced to die in prison. I perhaps 25 years later, I had a release valve. Right now, I wouldn't be here if Senator Skinner did not change that law, or put her name on that bill. I would still be in prison. I still had 10 more years approximately to serve. But here I'm before you talking about different release valves that we need. So I was sentenced to die in prison. People are sentenced to die in prison. And for those with determinate sentences who are not exempt, they are not exempt from a deterioration of life. It is a prison policy initiative research that shows and clearly states that every year a person is incarcerated takes 2 years off of their life expectancy.
Okay, we
That is
want
16
to
years,
get
so-
we want to get all this, and I promise we will, Adnan. We just need to.
Mike, one sentence.
Okay, last word.
This is my close off right here. This is the big part. This is the big one.
Okay,
I just
drum
want to
roll.
say close off is seriously, we need to remove ourselves from the idea of quote unquote time and quote unquote sentencing. We have been fixated on a number 10, 20, 30, 20, 210 years to life that gives us a false premise of administering consequences and a false premise of safety.
Thank you very much. It's a theme that we've been talking about for a long time, and we're glad to hear you. We want to hear more about your story. Ms. Polk, it's nice to meet you.
Nice to meet you as well. Thank you very much. So I want to first take you through a series of events that led me to sit here with you today. At 12 years old, my brother was shot and killed by the LAPD. Now, at that moment, 3 things happened. One is I lost all respect for authority, and not just police officers, teachers, parents, anyone in an authoritative figure, I lost all respect for. 2 is I no longer valued life, mine or anyone else's. 3 is I became desensitized. So anything after that, there was no emotion that was in me to evoke. Over the next 5 years, between the ages of 12 and 17, I lost my brother, 2 cousins, and a father. I had become a walking time bomb and didn't know it. There was no such thing as grief and loss. Let's talk about it. Let's sit down and talk about our feelings as a family growing up. That was non-existent. When I was 19 years old, I was living what I thought was a normal life until one day I got into an argument with a coworker that escalated to the point of me becoming so upset that I took the life of Diane Poole. I was on the phone with my brother at the time of the argument. He said to me, "Leave, go home, I'm on my way." At that moment, I knew Diane Poole was going to be killed. I used my brother as a weapon. I was charged with aiding and abetting, 2nd-degree murder. My brother went on the run, was never arrested for the crime. 2 years later, he committed a murder-suicide. So I tell you this because I want you to know the type of person that was placed into the system as a lifer with no guidance. I am completely responsible for the death of Diane Poole. I do want to say that. What I wasn't responsible for was everything that led up to the point of me killing Diane Poole. So as I was placed in the system, being told that I was not going to parole, there was no chance of me paroling unless it was in a pine box. As someone stated on this panel earlier, I believed I was going to die in prison. So therefore I acted as if I was going to die in prison. It became my norm. Over the next 9-10 years, I had accumulated several write-ups, including assault on staff, battery on an inmate, inciting riots. It was the same type of behavior. At that point, I was too angry to listen to anybody. So I served 17 years on a 15 to life sentence. It took many years for me to realize that I was mentally unhealthy. Physically, I looked fine. Mentally, I was sick. And once I acknowledged that, it made it very easy for me to then start my journey of self-healing and forgiveness. Developing mentally, working through the grief and loss issues while making the positive shift in prison was definitely difficult, which was expected because I'm in a hostile, negative environment. What I didn't expect were the hoops I had to jump through to get what was required for me and recommended by BPH for me to be suitable for parole. There isn't a process for lifers who need certain requirements in a timely manner to be met. I was told to take a grief and loss class after my first hearing, yet one didn't exist. So I needed to take an anger management class, yet the waiting list was over a year long, and the prison prioritized short-termers. Those were going home within 18 months because they felt it was needed for them because they were going home sooner. So I have these requirements now that I have been told to take that don't exist. So I have to figure out, how am I now going to work the system to get what I need to get without getting in trouble, without now being deemed as being manipulative, but yet still get the requirements I need. And because the only reason I was able to do that is because of the list of my disciplinary action, and I knew certain sergeants, lieutenants, and captains I had built a relationship over. They saw the change and they were willing to help. The thing is, not all of the women incarcerated and men have that. Not all of them were able to ask and go above and beyond. They're stuck waiting. They're just waiting. So now I have to wait a year to get into an anger management class. I can't put in a petition to advance. I'm now back at a board hearing and they want to know why I haven't did what I did, why I haven't did what I was told. So that in itself is a main issue as far as lifers in prison and my perspective on that. What I did, I went to my first parole board hearing in 2012. I put in a petition to advance and I was released on my second board hearing in 2014. And that is because what I did that worked for me and a few others, I asked others that were willing to be able to let me read their transcripts. I wanted to know what was being asked, what was being said. I took initiative to know I have 12 serious 115s. I need to know what they're going to ask me, and I need to know how to answer these questions because there is no one in here that's going to help me prepare for this because I have no idea the process of a parole hearing. So I learned the process, I made it work for me, and I was found suitable on my second hearing.
Well, congratulations, first of all. How long ago was that?
That was in 2015.
Okay. So I have a couple of questions I'd like to start off with. First of all, we're very thankful for you joining us, and there's nothing. It's impossible for me or others to put ourselves in your situation and really know what that process is like. So your help and advice and thinking about this is extremely valuable. And I think you all and Sam, who had to leave, are showing what people who's received life sentences and had their lives thrown away, yet have done extraordinary things and been productive, more than productive since you've been released. But you're not alone, right? I don't think that I'm going to guess that you'd be the first to say that there's nothing. There are plenty of people behind bars who could be just as successful and as you all have been. I don't know if you all listened to our first panel. It's been a while ago, where we had Jennifer Schaefer and some of the other parole folks on. And Adnan, I take very seriously some of your ideas about thinking reimagining the system as a whole. And that's certainly something that I think is part of the long-term project of this committee. But for the short term, we're really trying to focus on specific legislative changes to improve the process, perhaps incrementally and perhaps insufficiently, but improve nonetheless. So I guess, Ms. Polk, if we could start with you, if there was a way that you might suggest that we could create a way to expand the number of people who are successful at parole. And Adnan, I know you didn't go to the parole board, but you essentially went through a similar type of evaluation process, right? And I know that you've studied this a lot, but anyway, so Ms. Polk, to expand the number of people, to let out people that you know are safe to be released. So I guess that how do we expand it to make sure that we get more people who are safe to be released, who maybe don't have the resources that you had, the internal gumption to go find the parole transcripts and study and figure that out. I don't know if it's, just getting more programming in does the trick. Maybe it does. Is there a better standard? Is there a better, I don't know if you listened to that part of the conversation. Do you have ideas of how we might be able to safely expand the pool of people who are able to get out through the parole process?
Well, the first thing is more programming, and not just more programming in prison, but more programming specifically for lifers in prison on the subjects that are being asked of them. I facilitate a domestic violence class for victims at California Institution for Women. I am the only one that facilitates that class in prison, which means there's only one class and I can only take 15 to 25 people at a time. And there's only 4 classes a year. That's a very—
I'm sorry to interrupt. Who pays for that?
I go in, I work for Second Call, which is a nonprofit organization. However, I go in for free. I don't get, we don't get paid to go in California Institution for Women.
I understand, but it's part of your job from Second Call to do this.
Well, time out, no. So that is the way I'm able to go in, is through this particular organization, if that makes sense. So I don't, when I go in, I do not get paid. I am not on the clock when I go in to
this is just volunteer work.
This is volunteer work. And that's how it started off with the founder, Skip Townsend, that it was volunteer work. And I continued it because I felt a woman who was formerly incarcerated can have more benefit, and he felt the same way, to facilitate this class. So that is just one example of, there's so many women in prison who have murdered and killed their husband or spouse, yet there's only one domestic violence class currently at CIW. So that in itself—
and just to clarify again, that one class is you, and that one class is you volunteering your time.
Yes.
Independently. Okay.
Yes. And initially it was an anger management that Skip Townsend was going in to do. And when I realized that there wasn't a domestic violence class for women, I am a certified domestic violence counselor. So I asked those in charge of the particular programming, can I shift it to a DV class? And they all agreed that yes, it is needed. And yes, please do so. So that is one thing, to have specific programming for.
So specific programming for lifers. How about when your experience before the board and they're asking you to sort of, we talked about before, about discuss your insight in ways that, I don't know if you feel like that's meaningful, if that's a bunch of hooey, or do you think that's like a legitimate inquiry by the board?
Well, there's 2 parts to this, yes and no, but the no is because I didn't know what insight was. It's just a buzzword in prison, right, that I have to get insight. What is it? What does it look like? How the hell do I get it? Excuse me. How do I get the insight? Where do I get it from? Do I have to ask someone for it? I don't know what it is. I didn't know what it was. And it took me going, again, reading transcripts, being denied, and being told, okay, this is what it is. But it shouldn't have happened after a denial. That there has to be some type of guidelines in place to where it's laid out to me. I want to get it. I just don't know I didn't know what it was.
So in your opinion, and again, I want to get to Adnan and open up to questions to others. the difference between your first parole hearing and your second was merely that you studied the transcripts and learned the language of what they wanted to hear, as opposed to you participated in X program and really changed as a person between your first and second.
Well, no, because I did change as a person. I had already started my change over the years,
Okay.
already 9 years in. But the only problem was is I wasn't, although I was changing internally, I still didn't know the parole board process.
Or the language.
Which is why I was given a 3-year denial, not anything more, because I did change. They were able to see that. But yet again, I lacked insight, my 115s and remorse.
And so Ms. Schaefer talked about the parole consultation that they do 5 or 6 years before your board hearing. That seems like it was not helpful for you in terms of understanding the process.
Absolutely not. At that point, I was.
Can you describe that for us? Can you describe that process? What happens?
Well, for one, it's too early into the sentence. I was still getting in trouble, and I believe I had to postpone it once because I was at segregation housing unit the first time because I was continually getting in trouble. So it was too early for me to listen to anything, or maybe it was too far off. I'm not sure where it was. Maybe it should have been right when I got incarcerated or when I got to prison. And to be honest, it was a fog because I went into that doc hearing knowing me getting into all this trouble, just got out of SHU, was not going home. So this, at that moment in my life, it was a waste of time. So it should have happened sooner. As soon as I got to prison, somebody, some type of system needed to be in place where it was, you are not paroling in a pine box. These are the steps. This is what you can do. These are programming. This is a great way to start for a new lifer coming into the system.
Thank you. So Adnan, I was wondering if, again, I know you didn't go through the parole process, and I think we all appreciate your expression to rethink the system holistically. But in terms of if you had a magic wand here, a specific second look type program, where would you emphasize that we focus our attention?
Well, Mike, it's not a magic wand if it's only towards a second look, right? It'll be a magic wand if it's towards the first look. I'm just giving you a hard time. But I think that what we need
a limited
to do,
magic wand, a very small one.
That's not
A
magic,
small,
man. I would really say that we need to look at the misunderstanding of giving people a certain number or even life without the possibility of parole, and then determining for me at 18 years old, my fate was sealed, right? So I didn't have any opportunity. And real quick, I just want to add, when you talked about the parole board, I quote unquote prepped for the parole board, especially in the latter 8 years to my incarceration, which means it's not a public safety conversation. That was already deemed for me after I was convicted by the probation report. But it was more to, like you said, learn the language. I could have, you heard here insight, but how do I articulate it to a parole board that wants me to speak to them in their language? So I have to learn the language. That's a lot of parole board stuff that goes on. It's not so much about safety, and I know you know this, but I would definitely say that we need mechanisms for people to at least appear before the parole board. Why was I in there waiting? Why do I have to wait for the clock to tick for up to 25 years, a quarter century, and then present my safety to you or to the parole board commissioners? People who are sentenced to life without parole, I just did the numbers. There are Prison Policy Initiative, by the way, sent me these numbers in California. In the last 10 years, 9,154 people from California state facilities are out right now who were once serving death sentence on death row or sentenced to death, life without the possibility of parole, and life with parole in the last 10 years. And with LWOP in particular, which is life without the possibility of parole, people have found relief through the governor's commutation, who still had to go to the parole board. The governor just granted through his magic wand to go to the parole board sooner. And that has been 24 people particularly a year since the last decade on average. What that says is 2 people a month are coming home or once serving life sentences. Life without the possibility of parole sentences because of a governor's commutation or other legal reasons. So this just points to that we need to get rid of these numbers. What's the purpose of these numbers? Or the life without, which is the number 0? Why, you know, we still have Keith Watley's mentioned earlier, over 80% parole denial rate. So we're not saying, and then there's a governor's review after that. So we're not saying that to reduce the sentence and then just release them. No, like let them go, at least let people appear before the parole board, or this other opportunity like 1170 or whatever other system that we create for people to at least present themselves. You know, we know we have all the data. We have all the data. You know what this really reminds me, I'm gonna close off with this, reminds me of how masks have been politicized, right? We have science that proves masks save people, save lives, it prevents COVID. I mean, we have all sorts of data and science, but yet it has been politicized nationally. Similarly, we have data, we have science, we have research, we have all sorts of support and even anecdotal, like myself and Ms. Polk here, who are in Sam, who are telling you that this is what works, yet people have politicized what safety means. We need to go away from that.
Thank you. Do other board members have questions? Nancy?
Ms. Polk, I'm curious as to, I mean, you seem to have the fact that you were granted parole on your second hearing, is that my understanding? Is that what you described?
Yes, that's correct.
And yet you still, given your sentence, in other words, they could have denied and you still, it wasn't like you had a sentence that required them to release you.
No.
So can you describe a little bit about your experience, maybe not experience the parole board, I don't know if it anecdotally really, but just any insight you've gained in terms of what you think improvements to the parole process might be, or what are the downsides of the current parole process?
Well, the downside is that I have 2 to 3 people judging me off a stack of papers. That is the downside, because they do not see the change that have happened over the 15 years, 20 plus years that individuals are serving. So that is a downside, because I believe, I'm not sure who said it earlier, I am human. I have feelings, I have emotions. It's hard to get my remorse out. You know, it's hard as I'm talking to express everything I'm expressing when I have 2 very intimidating people sitting in front of me with literally my life in their hands. It's nerve-wracking. It's very stressful, to say the least, because I want to be very authentic, but then in the back of my mind, I want to say what I think they want to hear without being, you know, with being truthful, because I didn't want to go in and say the right words. I really wanted to express myself to them, but how it's so I didn't know. And initially, with the state appointed attorney that I had, who recommended me not to go to board, the day of my board hearing, she said to me, if you go into this board hearing, you are liable to get a 10 to 15 year denial, because the person before you who had less 1/15 as you just received a 10-year denial. And I told her no, I was going in with or without her, and I ended up with a 3-year denial. But that is because, again, of my confidence and my ability to go in there and articulate what it was, who I was then and who I am now. However, if that was another young woman or man, they could have easily taken the advice of her counsel and postponed, which would have been damaging. And me probably still being in there, because I would have postponed for 5 years, which would have extended me in there longer. So proper counsel is always the education behind what really goes on, what an attorney is supposed to do. Some people really think an attorney is to go in there and speak for them. So that, and also what can help is if there was somebody else in that boardroom, an officer, someone that can speak for character, that have watched and witnessed the growth of an individual from the beginning to the end, because that is very important.
That's interesting. So like you could call a witness or something to like.
Yes. And a character witness, we're allowed to bring in letters of the same sort, but I think it would be very helpful that I had this particular officer who I may have assaulted and now is sitting there in the boardroom saying, no, this person is a different person. And I would be okay if she was my neighbor. That helps out a lot versus trying to make a decision as a commissioner based upon what is given to them an hour before the board hearing.
What do you think about the idea that we were talking about earlier? If there were some sort of check boxes, like, you've committed these, completed X programming, haven't had a rule violation in 5 years. Would that have been helpful in that it gives you sort of like a guidepost? I know I need to accomplish these things and then I get out, or is that just arbitrary and unhelpful?
No, I think it would help if I had okay, this is what I need to do. And I actually have an opportunity, at least a chance to go home, then yes, absolutely. I would have definitely taken the quote unquote checklist and probably started my time off different.
Right. So that was my next question. You would have probably, so you said you started off being in trouble, but if you've been given earlier on, here's a menu, you get your GED, you go to these programs, you check the boxes, and in X years, you're going to have a real chance. You think that would have been helpful?
I think that would have been helpful, but not just that, that's part one, but again, two, have those check boxes available, not with a lengthy wait list.
No, that's the unbelievable circumstance that everybody here was shaking their heads. I don't know if you could see that, that they were telling you to do these things that you couldn't possibly do. So like, we get that that's ridiculous. Do other folks have questions? Assemblymember Collins.
Yeah, I do. Thank you, Mr. Chair. I was wondering if maybe we could get a sense from CDCR, and maybe the committee can do this, or Senator Skinner and I can do this, but I'm now curious about how many classes are being offered in our prison systems and how many of them are like free or volunteer based, because just sort of intrinsically, I have a problem with people doing time and then having them come out and go back in prison and work for free. There's this kind of plantation politics thing that's making my skin curl. So I would like to see if we could get that kind of data. And I do believe that it might make sense to dig a little deeper into the time issue, because the numbers really do seem to be arbitrary. And I'd be curious to get more information on that. But
the time between parole boards.
Right. A lot of the time, even sentencing, it's just, you don't really want to know how people come up with numbers, right? But they're very arbitrary. But Shanae, as you were talking, it was reminding me of people going into high school. And when you go into high school, the goal of high school is to get out and go to college. And so when you're there, it's really all about prepping and giving you information and tutoring and classes and prep work to prepare you for getting out. And my mind, it seems like that's how it should be for folks who are incarcerated, prepping for these hearings so that you're preparing you to get out. I mean, I can't imagine. It's not about keeping people in forever. So I was wondering if you could just give some additional sort of examples or insight into ways that we could fully prepare folks for the hearings and for successful hearings. I mean, it's as much about the programs that you said they should be offering, that they're asking you to take, but also how do we make the process less secretive? Because I don't know that having a secretive process helps.
It doesn't help. And I think a good suggestion would be, again, in the very beginning, because they have a lot of pre-release classes for those, the short-termers that are going home and have a actual date. They can get into a pre-release class within X amount of time before they're being released. There can be one for lifers, a pre-board class that will state I think one time I learned through Heidi Rummel coming in and doing an actual board prep, a real mini workshop is when I learned the outline and the series of events. And again, that's not open to everyone. I was involved in the long-termers organization where I was able to get in, but that's a cap, you know? So it's members, and then I don't know, X amount of other women can get in, but it wasn't at that time open to everyone. It's open to the amount of people that can get into the particular room that we're allowed to use on that night. So if I had known in the beginning of my sentence, this is the process. This is how your time can either go. It can go this way or it can go that way. It is really only two ways to go in there. And I chose the latter. I didn't know option A. I didn't know A was an option. So if that can be addressed initially, as well as this is what goes on in a parole hearing. And then with that infamous word insight, initially I thought insight was just into my crime. So now I have to sit there, now I have to talk about what happened when I was 10, 11, and 12, that maybe throughout the 15, 17 years I hadn't even touched on, but now it's bringing up these emotions that I don't know how to deal with, have never dealt with. Now I'm becoming defensive. I don't know how to deal with this. And I'm in front of two people again, who now can deny me because I wasn't ready for that question. So I didn't know insight was insight to, you know, childhood on up, you know, that can be of help too. Like, give me your definition of it. What is it to you? And you meaning you, Commissioner, that has my life in your hands. What is this supposed to look like? So now I can work on it.
You're on mute, Michael.
Sorry, Dean Richardson, and then Adnan.
Oh, Adnan, why don't you go first? And then I'm happy chair for Adnan to go first.
Thank you so much. I appreciate that. I really want to highlight that we cannot, in my humble opinion and strong opinion, talk about offering rehabilitative programming and assuming that the culture of prisons is a safe space to provide that rehabilitative programming. We cannot do that. I have been in classes where I sat in for these 2 hours and I listened to this person who I knew, but I did not know his story. And he described to me this very graphic sexual abuse that he went through at 9 years old. We both left that building, and that education department class, on our way back up to our cells, we were pulled over and strip searched by correctional officers, just randomly. It was a random search / random strip search. Right after he just got done talking about his sexual trauma for the first time. And it really reminds me of, and I haven't been to the military, but how I can, at least in my head, equate it is, we are offering PTSD therapy classes to a military veteran and then sending that military veteran right into the battlefield as this person leaves the class. We talk about these classes as if you insert them and that there is this pocket of air that you can just breathe it and not realize that, no, this is not a pocket of air because you're sending them right back into underwater. And correctional officer, how they are trained. I'm not saying that training is going to solve everything, but I was in Norway with Assembly Member Kamlager, and we both know the difference of people. I just quickly want to say that there was a correctional officer in Norway who I asked him, he's a hiring officer, and I asked him, hey, what do you look for when hiring, besides the obvious, what do you look for when hiring someone? And he says immediately and impulsively, he said empathy. He said, what I'm looking for to hire a staff is empathy. And we don't have that in our system. Our system's not built on it. The architecture of our prisons are not built on it. The people who govern these prisons are not built on it. I have to name that, and we have to acknowledge that.
Dean Richardson.
Well, I just want to thank, first of all, Adnan and Shanae for coming and speaking with us today. And I don't know if this is really a question and maybe it's more of a comment. After starting with parole at the beginning of the day and then ending with the three of you speaking to us. And I guess I'll just say it and maybe turn it into a question. And this was raised in the first part of the days. And so maybe this is the question that I have. Our country, our system, we have just failed a whole population of us, right? Of people. And what has been bothering me all day is that because we're on this particular committee, we get to talk about the systems that already exist, things like parole. And it has been impactful to me that there are systems like parole that potentially we should abandon altogether, but then they are sometimes providing a space, because society has failed to, providing a space where there is a moment where you now can really spend some time healing from the horrific things that happen in our society, right? And it is sad that we need to place people and incarcerate people in order to provide the services and safety and all of those other things that have been able to really help. But why do we have to, why have we gotten to this point? And there's so many answers to this, I know. That's why this is not really a question. It's just what I've been thinking all day, right? So we have to fix the system because it can help, right? It can provide this space for education, for programming when it works. I take your point, Adnan, really, I could not agree with you more, right? About, especially with regard to the story you just told. And so I'm sitting here trying to figure out then where we go next, right? Because the ability to fix our society that is broken, that has failed so many people, has resulted in us warehousing people in prisons and in jails. And once people are there, then we start thinking about how can we provide this help? How can we provide this programming? How can we educate people? Well, we should have been doing that the whole time, right? So that's part of the problem that I'm having as I'm listening here today. And then the second piece, I guess, that I'll talk about that you, I think Adnan mentioned this, geo group, right? And I will just put my bias on the table. I have a real problem with private companies coming into the criminal justice space, right? Like that is hugely problematic to me, like the geo group. So that's just my bias. I'm putting it out there. But they're getting significant amounts of money, as you mentioned, right, to provide some services. And yet, to go back to Assembly member comments about you, Shanae, because I feel the same way about it. And then you come in and you do volunteer programming for people, for battered and abused women. There is something so broken. And so I guess I'm just sitting here trying to figure out then, as we're talking today about parole and about resentencing, and now we have your powerful testimony. I'm just trying to get my head around the tinkering that we're going to be doing as a committee, because that's what it is. And I think it's important based on what both of you and all three of you have said. But so that's what I mean. That's not really a question, but I'm just trying to figure out how to make sense of what we've heard all day today. And so I'd be curious what your thoughts are. If any, you don't need to have any.
Ms. Polk, do you have any reaction?
Well, my reaction is it's almost a relief, like someone's listening and can hear what is needed. And my next reaction is I do run across a lot of people that hear what is needed. And it's the action and the next steps that I really want to see, because sometimes these panels can be so great. And I believe people are authentically involved in them. And sometimes the next steps I don't see. So that's my initial thought on, I would love to see this actually, come to some type of rotation as far as implementing a new process for lifers specifically.
I don't think any of us would be spending all the time on this if we didn't believe that we could really make a difference. So I hear that. It's certainly are going to be our effort. We're going to try. Adnan, do you have a reflection on what Dean Richardson said?